Have you gone through all the judgments, sir? My own judgment. Upside.
In this case, I have filing and introduction system on behalf of the guardians.
What is your right in the property?
I have no right.
Sorry, in this cause?
This primarily both the sides has made it impossible for the children to read. That is why some.
Sir, we are on a very basic question, sir.
Yes.
We are on a basic question that whether the writ of such nature is an appropriate remedy.
Read. Whether they
Second question that arises, whether the collector or the DM is competent to pass any such order, be it a preventive order, be it a restrained order, in relation to a private educational institution.
looking at from the law and order situation.
That is the subject, that is a state subject, sir. There is no doubt about it. Under
144 probably.
No, sir. And Schedule 7, Entry 1, I believe, is a law and order is with the state.
Yes, sir.
No doubt about it. We have not even a doubt in this regard. That can be done, law and order. But can the collector pass such an order?
Then I was going to go to the order proceeding and without prejudice, without joining issues which either.
We are not entering into those issues. It is, there are suits, there are proceedings which are pending before the court. Let it be decided there.
Submission would be that in order to maintain law and order.
That is a different, that is a state will take care of it. But not interfering in the administration of the school.
There would be that
The order is preventive that you cannot remove the principal.
status quo.
Can it be? Sir, I am asking, sir. Sir, you are a senior veteran in law, knows law better than any of us. Kindly tell me whether the collector has the authority to pass such order or status quo.
Anybody saying that I know law doesn't know law. He's always a student of law.
No, that is right.
We go on.
But we learn every day, sir. And you have vast experience, which is always recognized as paramount, sir.
But I am not infallible.
No, everybody. Everybody is not infallible.
But my submission would be, probably I think status quo can be given.
No, sir. No, sir. You know from the core of your heart, no, it can't be. These administrative authorities, can they? Under what authority, sir? Tell me, under what authority they can? It's a private institution. It is not an institution.
Let me start.
No. It's very difficult. My own judgment is staring at my face, sir. Have you got a Narayana school judgment?
In a CMP, I recently relied on your Lordship's decision and got a judgment in my favor.
This affidavit, I've given this affidavit.
This is what a Narayana school, which I have delivered.
When I have not gone to it. Let it come tomorrow.
Give it.
Primary facing what your Lordship says, it sounds reasonable. But when the law and order situation may rise.
No, that is, sir, you are absolutely correct. You are absolutely correct. So far as the law and order is concerned, it is a state subject. A state has the powers, the competence to see.
But he told SP and collector to look into law and order situation.
But he is also drawing our attention to an order of the collector, which says that you cannot tinker with the appointment of the principal.
30 sub-collector,
Yeah.
which is.
Whatever.
Oh, whatever.
Madam,
Same.
no,
One is an alter ego of another.
My lord, I have handed over. I just.
That is important.
Mine.
Answer me this.
I will-
Can he?
No, he cannot.
I will.
That's all.
He cannot and he should not. My
Your
lord,
Lordship.
That's all.
only I
Yeah,
claim.
wait,
We will make a clarification in this regard.
Your Lordship.
That so far as the law and order is concerned, if there is any kind of a commotion or a breach of peace or any kind of a tranquility which the government perceived, they will take care of that. That's all, nothing more than that.
I just put certain sign.
Interfering with the administration of a private institution,
They
educational
have
institution.
made it impossible for the students to go and
Your
learn
Lordship,
that.
That is
That
what
part
they will
will
do. They will do that. Their education, their entry into the school, the attending the classes, that should not be hampered.
But there is a dispute.
No, for that, they can use for requisition.
May I just bring that to your Lordship's notice and rest is your Lordship's wisdom, which is obviously much, I stand nowhere in that case. Your Lordships, what I wanted to say is this, Your Lordships, this writ application was filed by the writ applicant, by the present applicant. And they, at that stage, had challenged that order which they showed yesterday. That order today does not exist. That's the reason why he submitted that this.
No, it does not exist, miss.
That order, Your Lordships, when they went to the writ court,
Hmm.
what the writ court did is that first order, the writ court passed, is that I want the sub collector to look into the law and order situation.
That's all.
That's all the court said.
True.
Thereafter, Your Lordships, the collector's order comes. In the last date, all of us were there. The government councillor just handed over the order to us. So it was supposed to come on the next day, and all of us were supposed to apprise the single bench, saying that what is the good and the bad of the order. So
I'm asking,
Your Lordships, no, let me just place Your Lordships.
you are before the appellate court.
Yes, Your Lordships.
Yes,
To point out this, that if Your Lordships today interferes at this stage,
Correct.
maybe, Your Lordships,
Maybe.
the exercise which the 226 court is supposed to do
Hmm.
will be hampered. And Your Lordship, to support this, that's exactly what the court said. Your Lordships, may just kindly look at para of this judgment. Para 8 onwards,
Yes.
para 9, which I wanted to say, Your Lordship.
Yes. Give it.
That
Give
will
it.
also give us some time.
Oh, sir, it reminds me something else, my nostalgic feelings.
Single judge.
Yes,
What
madam, yes.
Exactly Your Lordship's concern are we going to address?
Yes.
Sir, going to address. Your Lordship, I'm actually the
From
director.
different angles, we'll learn it.
All right.
Which,
Your Lordship will look at para 8 and
Yes.
para 9.
yes,
Para 9, of course, is the concluding paragraph. This is basically a judgment which says that
just one minute.
interference. Let us be like-
I have a contrary decision in my kitty. I have a contrary decision in my kitty.
Your Lordship, I have read Your Lordship's judgment also in Calcutta High Court, but Your Lordship kindly address this situation. They approach the single bench, at their behest an order comes and you are not there. Next day, the order is served
So
upon
there are two
other person.
principles. There are two principles. These are originating from a civil perspective.
That's right.
If an injunction application is moved and pressed for passing an interim order, even if there is no reflection that the interim order is refused or granted, the law is that it implies that the court has refused to pass an interim order. And therefore, an appeal under Order 43, Rule 1R is maintainable. There are second line of thought this. If this is the ratio that intra-court appeal against the interlocutory order is completely taken away.
No, Your
I have some judgments this is what you are referring to, paragraph 9 and 10 of the judgment.
When creating a finalization of right.
No, sir. It is once an interlocutory order is passed, it means it has decided the right of the party tentatively. I am not saying finally, tentatively, and therefore why the legislatures, while enacting the Civil Procedure Code, made certain orders appellable in nature. Why not the revision?
Yeah.
Because they know the scope of the revision is much lesser than the scope of an appeal.
Yes.
104 of the CPC should not be there in the book. Order 43, rule 1 should not be there in the book. If every interlocutory order is not susceptible to be challenged by way of an appeal. This is what you have said.
Your Lordship, that
Should I accept that?
It's a total bar.
Sir, what are you talking about? You are referring so vigorously, you are referring a judgment. We'll see.
Very conscious.
And these are all only a persuasive value, not binding on it. Not binding on us. No. Yes.
Both of them stand in the.
But being here, I am guided by my own judgment.
While you are here, you are part
That's why I'm saying I am guided by my own judgment. How can I take a different route?
No, but what my lord is saying, we are unable to fathom one thing, that the very case that you have been agitating upon is the question of maintaining law and order. In the guise of maintenance of law and order, whether you can dictate the authority not to enter it.
See that Indian.
You see para 4 and 3 and 4.
Anyhow, the senior most counsel is asking for a day's time.
Lordships.
He's asking for a day's time.
Tomorrow.
Tomorrow. I'm more than happy.
Tomorrow they have to.
So you have really hijacked his prayer.
I'll just have a
Yeah.
Hey. To pay. What are you saying?
It is related to the imposition of penalty to that extent under rule.
Oh,
rules.
Yes.
And you have this order.
Oh, 5 lakh rupees.
4 lakhs they have imposed. This order contains two parts for seizure of vehicle and imposition of penalty. Regarding seizure of vehicle, I file application. Court says that release the vehicle by deposit of security. Regarding the rule 51, still penalty will still operate.
I think there is our judgment which says that it is within the competence of a court, not by the authorities.
Yes, sir.
Consistent.
So paragraph 9.
We have held that it is within the competence of the court to impose. You can't impose.
Paragraph 9, your lordship, start rule 51 and 52.
This is what is there. That he shall expose himself. In view of our own judgment.
It's covered by that, 2009.
I have already dictated.
Hello.
Item number 2.
Where is my synopsis? It was there. This is the right on. Funding. If you do not want to continue, we wanted a refund of everything. You can't sit over it.
Actually, one thing.
2007 minus the break, the what that is because of the representation. Further, the authority also.
What he is saying, his father actually purchased the property, sir, and obtained also the NOC from a Prussia. Take it.
Minus they want to dispose of representation with the records of 2007, so they asked to go.
No, in
Now he has included everything in the writ petition. Now everything is before you.
2007, a clarification was also sought from VFO.
Sir, whatever be the reason, the bottom line of the story is that till date you have not been, though he was allotted, but you have not allowed him to operate. He says, I never operated even for a single day. So once you have decided in that fashion, give back my money which I have deposited. And then he is claiming compensation. That you will decide what to do.
As a appropriate order, so the interest of the 12% merits.
Obviously,
Yes, yes.
obviously. But we are not going to pass an order. We are simply saying that you consider the representation. Though I am against that.
But here is a bit case we have to. 25%. 26.
Look,
This is
3.
Yes.
The last appeal will.
How can you proceed on the basis of a draft?
Millet, last appeal, we prayed for satisfaction to find counter application.
How can you proceed on the basis of a draft?
Thing.
Millet, we are filing counter
Yes, let's
affidavit
stop.
today, Millet.
It is not a draft.
Millet, thereafter some subsequent.
I am asking, is a draft notification.
Millet, it was.
So, till date, can you act on the basis of a draft?
Millet, there is some subsequent order. Thereafter, some other notifications are also received, Millet. We are filing counter affidavits today. It's a clarification.
Even in the draft notification, the area does not come.
No, that is how clarification was sought. Nowhere it is confirmed. Even nowhere confirmed that whether this particular village comes within the area.
Annex 10 is issued in
No final demarcation has
No.
been made. Whether this comes within the purview of this eco-sensitive zone or not.
Millet, my instruction is that, Millet, there is final demarcation and it is coming under that, Millet. We are filing counter affidavits today.
Today?
Yes, sir. That's my take on it.
pursuant to the direction of the Honorable Supreme Court in PN Godavari case, my lord, the central government issued draft notification. In the draft notification, the area does not come even in the draft notification. How they, your lordship kindly see page 71. Annex 7 is improved order, Annex 7, my lord, page 67. And after 15 days, Annex 7, Annex 10, page 71 issued to clarify whether it is coming under. And draft notification is March 2026. And they illegally have no authority, mining officer have no authority.
Yes,
Another case, the lordship can.
The pivotal issue involved in the Sir, if it comes under the ESZ, then sorry. We have to first hail that it is outside. No. Next.
Item number 4.
Lordship,
Under the same heading for that matter.
Lordship,
Oh.
the petitioner is before this honorable court with a prayer that the representation is pending with the opposite party number 4 since
So there is already a rule 64. Is a rule 64 matter?
Yes,
Lordship.
No,
Yes.
extension, I mean.
And
Ms. Das, is it a rule 64 matter?
Yes, my lords, rule 64.
It
my-
appears that you are still there in the court presence.
No, my lords, I am at AG sir's chamber briefing him certain matter, my lords,
So that is within the court premises.
in his residence. my lords.
Residential something.
Oh. Yes.
Lordship,
64 matter. Yes. That order, where is that? Rule 64. Many orders are there. Rule 64. That's it. Yes, yes. They rule 64.
Lordship,
Item number 5.
Let them take a decision, sir, on your application. We have fixed the time. Government to take. Yes, call the next.
Item 5, sir.
5. Just one minute.
Like so, Lordship.
Oh, Baba. These have expired. Lift it over. What?
That's what you also may recollect, one and a half months back, you also had judgment in respect of the same petition application. The since my lords is setting the lordships, just apply the lordships, I take the lordship to page 80. Page 80.
Now what is this? Lifting, they wanted.
You also may recollect, there was a Supreme Court direction to.
I understand. I know Justice Gawai's judgment, the Gawai's order, there are there. After the common cause was delivered, many applications came to be filed.
Yes, my lords.
Supreme Court has extended the time. 12G, 1 GG or 12 HH, 1 HH. Yes, Mr. Nanda?
My lords?
12 1 GG and 12 1 HH.
Yes, my lord.
What?
But
The apex court has been granting a time.
for the situation
Time
here,
was granted on several occasions. In spite of time granted, he did not turn up. Ultimately, finally turned up. His representative came, but did not put his signature at the time. Did not put his signature.
He
Did not put his
Or did
signature.
not put his signature. Okay.
Saying that I was not present. But this is the field taken that the calculation of total stock. Behind his back, it was not there, all this. Factual is not correct. The representative was present several times.
I am asking you, sir, even after the expiry of the period, he has a right under 21GG to remove those minerals which he has extracted within a particular timeline. Within a timeline, sir. 12(1) HH also gives a buffer time of 1 month more after giving a notice. Now, those period has expired. Now there has been a consistent view of the Supreme Court to permit, to lift, because the law says that the moment this period expires, then the entire ores or the minerals which they have extracted will waste into the government. And the government may sell it by auction. If there is any loss to the government, they can recover from them. That is what is there. So the property really vests into the government. But you are, sir, where you have sold? Have you sold it?
No,
I am asking, sir, ascertainment of a loss must be a liquidated damages to be ascertained. What is the parameter? The stock is still piled there. You do not know what would be the auction price one can offer, which may exceed this particular amount.
even the report says that according to their books of account, the stock position is not tallying with the stock in the field.
my lords, 10 years. 10 years, by the
That is
20% variation, bound to happen, my lords.
Since
Since
2022, notice has been
Yes, I
issued.
took my lawyer senior, since Billy has brought up this issue.
The order itself.
My lords, they are, allegedly, they alleged that the.
It has increased or decreased?
Decreased.
Decreased, obviously. So there is rain, there is.
For that purpose, notice is issued to come and we should verify. He is not turning up.
My lords, verification done.
No,
Joint,
With great respect, my lordship, they are on the record. They are on the record.
Verification was made
Your lordship,
after 3-4 years because of delay caused by him, and the representative was present but did not notice
your
it.
lordship, gives me just 2 minutes. I'll just clear the entire picture. On their alleged allegation that my lease period expired, your lordship knows, on 25/10/2025. Now, thereafter, I approached this honorable court to claim my right with regard to the expiry being 23/5/2026. During the interim, my lords, entire period from December till April 2026, irrespective of what was happening, they carried out continuously verifications which are on record as filed merit application. They carried out verification and they said that there is a shortage. Thereafter, pointed out that your forest department has grown on my oars. They have carried out plantations on my oars. Subsequent thereto, they agreed to my joint verification. I was present. It was done in, it's there, my lords. Joint verification was done on 27/4/2026, which is under Annex 16. And they clarified that those plots which where the iron ores, they are alleging shortage, are in fact having plantations on them. Now, thereafter, immediately, your lordship has come up with the judgment for which they now say that since the lease period has expired, now you, under Annex 27, they have alleged we are going to take up an entire stock of yours, including the iron.
How can it be?
Okay, my lords. Entire thing is on record.
He has a right. He has a right under 12(1) GG.
And every time
You can't deny his right under 12(1) GG.
That's what I will check up. But
What check up?
In the present
What
case,
check
they
up?
are challenging answer 9, the demand notice.
Right.
The demand notice, they are challenging demand notice. That is answer 9 case.
years person, my lords. Lordship has looked at Annex 30, summons from the Honorable Calcutta High Court, my lords. Summons from Honorable Calcutta High Court by the suits instituted by the clients who were paid advance to the petitioner. Annex 36, your lordship sees.
Page.
401 to 412, even FIRs have been filed against him because he's unable to deliver these products. He has taken advances to supply them. Now, with the kind of harassment the state is meeting out to the petitioner, he's unable to deliver these quantities. My lordship, see, they have given the entire 30 years. Starts from page 400.
This is a commercial suit.
First,
Before the commercial
Yes.
of the High Court. That's why
He has challenged his demand notice under answer 9. The demand is for 29 crores 33 lakhs. And therefore he wants to lift. So whether lifting is permissible or not, then that part will take also.
Sir, under GG, if they lift, they have to pay whatever the royalty which is attracted on that quantity of the ores.
Yes.
They have to pay.
Yes.
There is no, I think, shocking of this responsibility. But the difficulty is the manner in which the demand is raised. Can you do it in this way? He says the joint verification has been done. It is found that the plantations have been done by the forest department on the ores which he has extracted and was kept within the lease area.
And that demand notice was prior to the joint verification, for which the demand notice was raised. I immediately objected. After them, thereafter they have carried out the joint verification. Now they are again coming with it. And every time, my lord, I am coming with my request. Every time.
If the order itself and under answer 9 will be seen, the submission is made for which is factually incorrect. Several so-called notices has been issued, several notices have been issued for joint verification. It did not turn
He
out.
says that the joint verification was done after the issuance of the notice.
After the demand notice has been issued, the joint verification has been made. Under what circumstances that has been made, I have to check up.
But what is the outcome of that? He has already annexed those documents.
That's what I have to obtain instruction after demand notice finally issued. Thereafter another joint verification.
Now you must look at text 59 also. They have taken advance royalty and debt have paid by law. So lordship say entire steel mines website. Entire advance royalty have paid way back 2021 just because to supply consequent to the Honorable Court's direction, my lord.
Yes.
Page 49, 59, your lordship has looked. Entire their website itself, previous have paid advance royalty, everything, dated, everything. Every time I request for lifting of the oats, they come up with some kind of demand notice.
No, not sir.
Yes, yes.
So sometimes the order itself speaks.
They are denying that
The order itself very reasoned order. If a lordship will permit, I will read it. How many times notice has been issued, he did not turn up. Finally, having no other option, a date was fixed. On that day, he agreed to come. On his request, date was fixed, but it did not turn up. A representative came, was present there, but did not put the signature saying that I am not taking the consent. Thereafter, demand notice has been. Another joint verification has been made in 2026, 2 months back. I have to obtain instruction why that joint verification again.
It appears that They have not done that, they will lift.
My lord, your lordship, annex is 27.
What?
Your lordship has to look at
But
annex.
simply they have raised a demand.
No. In fact, my challenge is to annex 27, my lords. Annex 27, demand, my lords.
Have they said that they are going to sell? Are you going to sell?
Hand over position.
No.
Annex 27, lordship.
What it says.
They were directed to concern. Hand over
Your
position.
lordship, distance them really.
Position is with them.
But they are.
But after the expiry of the
Only-
lease, there is no
yes.
difficulty. How can you retain a position? You'll have to remove it.
Yes, I'll remove it.
Uh,
They give me some time, I'll do.
So that is what I'm saying. So nothing is going to happen in the meantime. Next week, next Tuesday is going to.
No consideration, because that
Oh.
letters, I submitted letters.
You, by this time, you have understood me.
Yes, my lord.
Unless I am fully satisfied that's why I'm asking. I understand. Are you going to take any steps, Mr. Swai?
Yes. Yeah, understood. Also does not say that we are going to leave. We are not to say.
That's all. Next Tuesday.
Language,
Give it.
language is quite clear, my lord.
Ah,
Not there.
anyhow.
Item number 6.
My concern that would not have been there, my lords, on last occasion when your lordship was dealing with the rate application. Multiple times they issued notice to evacuate me, my lords, from that place.
Tuesday, nothing is going to happen. If occasion arises, mention the matter.
They have assured your lordship that they are not going to disturb.
Yes.
Item number 6.
So, my lord, Annexure 8 is the subject matter of challenge, my lord, page number 96.
Oh, it's a period of lease.
My lord,
Where is the judgment of Justice Muralidhar? It is to be reckoned from the date of the registration,
yes, my lord.
not from the date of the execution. Sir, under the rules itself.
But my lord, here, please have a glance to the Annexure 5, page number 66. Page number 68, my lord. Point number 3, lease period, up to 31/8/2027.
Yes. How can you do it from the date of execution? It should be from a date of registration.
Yes, ma'am.
So your letter of 13/7, so that it was executed on 16/4/21. So the lease period will expire on 15/4/2026. But the registration was done later on. When it was registered.
On, my lord, 16/12/2024.
So 24. No, 20.
The first
22.
it was executed on
No, registered.
16/4/2021.
That is the execution date.
Yes,
What is the registration date?
In fact, lordship, they have done in two-phased manner. As they have done it for 1 year, lordship, then it is extended.
I just wanted a first registration.
Lordship, page 16.
Page
16.
16
But still,
or 16.
No, we find it in Annexure 2 is the release date.
page 30, lordship, page 30.
This is
Page 30, lordship.
registered on part 2.
No. Where is the date of registration? There must be before the registry office.
District
There should be some kind of the endorsement of the registry office.
This is district sub-register.
Sub-register has to. What is the date?
District sub-register is dated
Which-
21st day of, this is the one,
Which-
42.
42.
21st day of September 22.
Oh, so it has to reckon from that day. Where is that provision which says from the date of registration, not from the date of execution? Unlike the Registration Act. Justice Muralidhar's judgment is also there. He has said so.
Rule 43(2).
Yes, show me. OMMC rules 2016. 42.
43.
43, 2, Lordship.
The date of commencement of the period for which the prospective license or marriage license is granted shall be the date on which the newly executed
The
deed
date of
registered. This is
executed deed is registered.
2. When it is registered.
Registered, very clear.
So it will reckon from that day. Mr. Roth,
My lord, yes.
it's too settled. Your own act,
Yes, my lord.
unlike the registration act.
Yes, my lord, it is there in statute. But there is one other aspect that I want to draw my lord's attention to. But there is a appeal, my lord, this, they are challenging Annexure 8, which is issued by
Appeal provision.
Yes, my lord, there is an appeal provision, and the appeal period is still subsisting. It has not expired. So they can very well approach the direction, my lord. That is provided in the statute, my lord.
If there is a manifest injustice apparent on the face of the record, will we direct them to go for?
That is,
It's a manifest injustice. How can you treat it contrary to these rules?
Not the first lease agreement, my lord, it was executed in the year 2021.
So subsequent are the extension.
Subsequently, they have extended.
Then
So, my lord, if 21 it ends in 26, my lord. 5 years ends in 2026.
from the date of September,
2000, yes, my lord, September.
it has not expired. So
September.
we are in August.
Yes, my lord.
So
That has to be.
that is what I am saying.
That has to be. From the date of registration.
Yes.
it
Has to be.
Yes, my lord.
Yes. Mr. Duloi,
Lordship.
don't go by our version. If you go into the record, find something differently,
No,
we'll
Lordship.
pass the different order. Ah.
Lordship, very Lordship.
Oh no, there is something hidden.
What hidden, Lordship, I am saying, I'm saying, Lordship, what they have done the blunder, Lordship, by executing 3 different sale deeds, lease deeds. Lordship has to be, it occupied for 5 years. They didn't do so, Lordship. They made it for 1 year. Lordship, then they come up with the second lease deed. Now, Lordship, can come to Annexure 5. Annexure 5, page 66.
Yes.
Page 66, Lordship.
Uh,
Page 66, Lordship, I state Lordship, come to page 60. Page 60 is the Lordship.
no, 66. Let me see the date.
Lordship.
16
16 December 24.
Oh, then Lordship, can come to page 68. Their own agreement lease period up to 31/8/127. Lordship, page 68. Lease period date.
Yes.
How can the Lordship, now the mining is saying that,
Oh, I've seen that. I have. Sir, what are you doing?
But this is something, because I also was surprised why this date is mentioned. Even though 5 years ends in 2026, how they have written 27 million is something. But Miller, fact is, Miller, it started from 2021, so it has to end in
For the
2026.
third year.
Yes. They have taken it in the 3rd year. Guaranteed for the 3rd year.
And this was of 2024.
Sir, 24 to 27.
3 years.
up to for 5 years. And it will be 5 years, Lordship. Then date of registration till the Lordship completion of the registration. They didn't do so.
Is it not a fresh lease? Mr. Roth, it is a fresh lease.
It is a fresh lease.
No?
It is a fresh lease. But Miller, as per the tender condition, Miller, when it was put to auction,
Sir, I do not know. You can vary the tender conditions, whatever. It was for a
It's always for 5 years. That is settled Mullers. But this is a fresh lease. That is 2 Mullers. But it is also a fact that it is always for 5 years. And it is clearly mentioned in the tender condition itself.
not tender condition under the statute also, not beyond 5 years.
Yes, ma'am.
There is a
Yes,
lease
sir.
period
Yeah.
cannot be granted beyond.
Lordship. Up to 10 years.
What is there?
Rule 8, Lordship, Rule 8, sub Rule 5.
Rule?
Rule 8, Lordship,
Huh?
sub Rule 4.
The maximum period for which a query lease may be granted shall not
10
10
years. Subject to some
such terms and conditions.
as prescribed by the competent authority, provided that minimum period of which may such lease may
Shall be 5 years.
That is why I said, my lord, in the tender condition was stipulated 5 years. And in fact, in the first agreement, which was made in the year 2021, also it is mentioned 5 years.
But that is now insignificant.
Yes, my lord. But, my lord,
Subsequent to this.
the intention can be gathered.
But kindly visualize, there are two aspects which is coming. One says the minimum period, another says the maximum period. So if that leverage or a freedom is given, then at least you cannot restrict the lease below 5 years.
Yes, ma'am.
But you cannot exceed it beyond 10 years. If it appears that his lease deed is extended in between, so will it not be coming under the 4? Why not? It should continue till 27th. It says the maximum period may be granted shall not exceed and shall be subject to such terms and conditions. So this is what a new lease deed you have come with the terms and conditions as may be specified by the competent authority. So that is not that the maximum is 5. No. It is the minimum which is 5.
Yes, my lord. But, my lord,
So it can exceed 5,
it can, my lord.
but cannot exceed 10.
Yes, ma'am. That is right. But my lords will have the first lease agreement.
And there is no
Wait,
reflection, sir. When you are
wait,
executing a lease deed, there is no reflection of a past event. Interesting.
Actually, it is, I also asked them, how come normally
Stop.
every lease is executed for 5 years straight? This is the first time I am seeing something like this.
What one?
Reflection of the past period.
Yes.
There should be in a recital, there should be some kind of a past events must be recorded that he was granted a lease for a period of 1 year, then for another lease for 1 year, now for 3 years, cumulative 5 years. Everything has to be.
Yes.
Nothing is mentioned.
Then, if it is a fresh lease, then again, and you realize.
Yes, Mullah. There are only two things, Mullah. First, the first lease which was executed in the year 2021. Mullah, you'll find it at page 30, Mullah. The relevant portion is page 33. This is the first agreement, Mullah. Page 33, part 1, point number 3. They say, Mullah, the lease period is 5 years. And Mullah, second, page 33, Mullah, towards the bottom.
In the first lease.
This is the first lease. This is of the year 2021.
Lease period, long-term lease, 5 years from the date of.
Yes. So this 5 years then.
Oh, then kind of
Look, that is one
That
aspect.
is important.
4 is Mullah, they say the period of the deed is 1.
Yeah.
But the lease period Mullah above that. They say it is 5 years. And why they say it is 5 years is Mullah because the tender condition for this.
We don't have when lordship offer.
And the authority Mullah change the tender conditions. Mullah
He's trying to take advantage of your own mistakes and wrongs.
I understand. That is my fallacy. That is. They have done it in this manner. That is why they.
Because again, 5 clause 5 and other goes as if it is for 5 years. Because the minimum extraction that you
Yes, Mullah, that was the intention. But somehow.
What is the provision for settlement of the quarry leases? There is a specific provision.
Rule 27, Lordship, that is. Grant of relief, that is.
Yes. To the last lease deed? Last lease deed? If there is a mistake which they have shown about the currency of the lease or a period of the lease.
Please, Lordship, firstly, they're saying for 1 year, Lordship.
Correct.
In Lordship,
It should commence from the date of registration.
from the registration, Lordship.
Notification.
That is for 1 year, Lordship.
No, I understand.
So the period, they're saying lease period is for 5 years.
I'm coming. I anticipated it. Then my answer will come.
Lordship. Now,
That's
Lordship, in
1 year. Then
this agreement, they're saying it is for 3 years.
can they do it? If it is a fresh lease, can they do it?
They have done it, Lordship.
Divorce 27-1,
They have done it, Lordship.
then it's a wrong. So we'll say cancel that.
That's it for it again. Reason being, Lordship,
No,
this
sir.
is the provision.
Mr. Roth, it cannot be done. It has to be counted from the date of registration and the period has to be given to him. That's all. That has to.
Lordship, that's.
D'accord.
Item 8 simple, I want to withdraw to file the repetition in shape of PIL under the provisions of Odisha High Court PIL rules. Because fundamentally this repetition has been filed.
8 and 9.
No, only 8 million.
Only
Nine.
8.
Withdraw.
Withdraw with the liberty to file as per PIL.
Yes, fetched before the appropriate forum for the self-relief. It is 9.
Item number 9.
9 million, this is a matter for extension of lease period. The
64.
obliged.
But you kindly have a glance to page 10 towards the prayer.
That
He needs direction for issuance of transit permit. Now,
Oh,
that
lease-
no, sir. No, sir, you can't do it.
well, transit permit, since they are.
No, sir. No, sir. You can't change the prayer.
Literally, I have made the prayer because.
No, sir. No, sir, you can't.
Then you should consider my lord on this basis of existing prayer, my lord, because throughout before the authority I have paid, because they due to not any mistake they have given lesser period to me. My lord.
No, whatever. I do not know. Transit pass.
Transit pass, they are not giving the agreement period is over. They
So
are,
let us say why they are not giving a transit permit.
The lease period is already over.
Over, and they wanted a transit permit after the lease period.
After the lease period.
That cannot be done.
my lord. This because I have no fault, my lord. Initially, lease has been granted in my favor in 2006.
No, sir. That prayer we can't. That is a very simple prayer.
My-
Where is the application for transit permit?
Annexure 1, my lord, I have filed.
No. What?
Big
Application.
petition before the authority, page 12 and 13, my lord.
Supply.
Oh, because the agreement executed, thereafter for consent order, there are not.
That is on this is on 21/3/2024 when the lease expired.
My lord, that has not been expired period, my lord. Lease, subsequent lease date.
When the lease expired.
Page 62, Miller, it expired on 27/2024, Miller.
27,
7,
2024.
2024. Page 62 towards the bottom.
62 page what? Bottom para.
Yes.
And it was the extended period.
Correct. So why you did not issue the transit part for that year?
It had actually with this document pillar.
Huh?
Supplementary, the lease deed was executed on 1st December 2023, but they consent order to granted after
The application.
in January 2024, my lord.
How it is received.
At page 81, annexure 16. The lease agreement is initially executed as per direction of the Honorable Court. Thereafter, they permitted me after 1 month by giving consent and not issuing any transit part.
Page 12,
Madam.
please. What is the date of the application?
Page 12 of the year 12/3/2024.
What is the date you have written below your signature?
4/3/2024.
What is both thing?
4/3. Style of writing. 4/3.
Very interesting way of writing a 4.
Sorry, my person very to very. Series I have from very beginning from my I have submitted application on 8 February 2024. I have submitted application without any fault. I have furnished. Or proportionally amount may be refunded if they are not possible to.
No. No. So it is not 4, sir.
Sir?
It is not 4.
Previous application also I have filed.
No, sir.
Okay. Yes, 13
It is not 4. It is not 4/3. It is not 4/3, sir.
So if your lordship consider
It is a handwritten application of the applicant himself.
My lord.
Page 12.
My lord.
No.
That's it, kindly.
Oh, how he writes.
And here it is.
And page 13, my lord. My lord,
Yes, sir.
page 13 may be considered, my lord.
No, sir. Page 12 I am considering.
My lord.
At page,
You are talking about 4/3. I have a doubt.
let's see, at page
And
40,
that may be ignored, my lord.
No, I ignored. You have done certain documents and you're lying.
And that is the document I cannot say more, my lord.
Yes, if it is of 21st September, March, how it can be received on 12th March?
That my instruction that 4.
Sir, you have written 4 above in the content of the letter. How you have written 4 and how you have written 4 at the bottom. I think that is 21.
It's very clearly visible to be 21 and in the above at the body. See how 4 has been written.
And even at 2024, how you have written 4 there?
and at page 14 minutes towards the bottom, let's just see that 14. That's this.
Again, this.
Hmm.
And access.
46/124.
No, sir.
Well, your lordship asked.
No, sir.
But simultaneously, can I advance to page 13, my lord?
No, sir, we will not. Sorry.
13, page 13 is
The
also.
person must come with a clean hand, not by manufacturing, not by, we are sending it for a handwriting expert. And if we find, then we can invoke our powers. Not under old 370, but now under BNSS. You can't make a document.
Minor discrepancy as pointed out, your lordship, that appears to be
No, sir. If you want, we are sending it.
formatted to withdraw, my lord. Yes.
No, sir.
Your lordship, my lord.
There's nothing. Seal is not there. Even the seal is. In all the documents, there is a seal, but in this document, it is not.
So, that's that mistake, my lord, on part of the petitioners.
No.
Every.
Their letters, they say they wanted a transit pass. The petitioner sought for a
Item number 10.
Where is the order dated 29/11, annexure 1?
Already had it several times.
Several times.
Doctrine of factum ballot and the de facto
Oh, this is
same. Doctrine of factum ballot.
HON'BLE Lordships.
My lord, sir.
There's a series of writ petitions on the same issue.
The sub-collector
Series of-
conducted auction. Now these did execute it. Basing upon an earlier consent order, 2022, though the sub-collector did not even have power to cancel. Under the rules, it is the competent authority to cancel. Sub-collector has cancelled it. And question is, Lord, it was argued before my lords. I don't think I have cited judgments that Pulin Bihari Das and others. Just to remind you, lords, that Gokharaju and others judgments were cited. They are there on. But the authority, even if do not have the power, if I conducted an auction and in furtherance of that you have executed the lease deed in favor of the private person, then subsequent thereto, on the ground of jurisdiction, you cannot cancel it. The reason being that doctrine of factum ballot and de facto theory. I have cited those judgments, Lord. Thanks. And on that ground, your lordship wanted a reply from the temple. Temple has filed a counter. In the counter, I find that in one paragraph, though it appears to be ChatGPT counter, but then yes, kindly see in one
so
paragraph.
is Who is there?
Mr. Swai is there.
Not Cloud. Not Cloud.
Kindly see page 12 note. They have another para 41. Para 41, yes. That the de facto doctrine has a limited and well recognized purpose. It protects the validity of the official act performed by a person who occupies a public office under the color of lawful authority so as to protect innocent third parties and preserve the continuity of public administration. So this is how I believe that they have admitted the whole issue.
This is a wrong interpretation, my lord. Public
What you have
office,
written
lawful
down-
public office. Sub-collector is not lawful public office. His tahsildar is lawful public office. It's a wrong interpretation of my senior. I'll look at it. There are, I have some.
It's not a debate which is going on that you will immediately jump. Let him interpret in this own way. You just take a note. When your turn will come, you argue.
Kindly see, kindly see. Then, but I'll just cite your lordship the judgments and also the kindly see.
When the amendment took place,
Lord, yes. In the year 2004, the earlier 2004 rules, a lease beyond the value of 50,000, it was the sub-collector was the complainant.
Beyond the value of
50,000.
Okay.
Sub-collector was the competent authority. Under the rules, it is there. So, lordship would like to see it.
Anyhow, then
In the year 2010, RDC issued an official letter for all purposes saying that in case of temple administration queries, it is the sub-collector will hold auction in respect of the queries belonging to the Lord Jagannath. 2010, such a letter was issued, and that 2011, that is part of the record. Now, in the year, the auction, if you will kindly see, the auction notice here was published 22nd of November 2020. That is page 18 of
20.
Yes. It was 2016, the rule got new rule came into force, 2016. Now, under the 2016 rules, Tahsildar is classified as the competent authority. Tahsildar is classified as the competent authority. Sub-collector has become the appellate authority. Sub-collector under rule 46 of 16 rules is the appellate.
Sub-collector is higher in rank than of the Tahsildar.
Yes, higher to the plus. The sub-collector has become the competent authority. Now, in the year 2022, the entire auction of this sand sairat and minor mineral has been transferred to mining department.
22.
That notification is there.
Yes,
23, I'm sorry, December 23. 22. Where are you seeing from? December 22, it got transferred to the mining department. Now, it is at this juncture, an order, a consent order was passed by a coordinate bench of this Honorable Court with consent of the temple in another tender notice that sub-collector is not the competent authority. The tender notice in that particular case was passed. It's a consent order. Now, relying on that order, sub-collector here has cancelled the lease deed which is already executed in Mecca.
Prior to that judgment.
The lease deed is post-judgment, 2023.
And the sand sariat was granted prior to the judgment.
Lease was
In my case, it was granted prior to.
Auction, no. Auction here is 2020, prior to judgment. Auction notice is prior to judgment.
Declaration that you are the highest bidder was prior to the judgment.
Prior to this. Yes, it was prior to the judgment.
Only the lease deed was
executed in the year 2020. 23. 24/8/23, page 81.
Okay.
But primarily two issues. One, even accepting that sub-collector has cancelled it, if lordship see, under Rule 57 of 2016 rules, power of cancellation lies with the competent authority under 2016 rules, that is Tahsildar. Kindly see Rule 51, sub-rule 7. The only provision for cancellation of fees. Now, temple is a beneficiary. Temple has nothing to say about all this. Temple administration, they are the beneficiary of this. And not, lordship see 51(7). Yes.
How can a sand bid can be a part of the property of a temple administration or Lord Jagannath?
Student query.
It's a natural resource.
Right, sir.
How can it be property of
It should be of the state.
true?
Should be of the state under the
True.
Municipal Act.
That is what I'm thinking.
Yes, of the state only. But land is recorded, man. Surface may be of the Lord Jagannath, but anything beneath surface belong to the state. Now 51(7) says, in case of, this is the only provision in the rules. In case of breach of any condition of the lease deed, the competent authority may give notice of 60 days to the lessee to rectify the defects within time specified, and if the lessee fails to rectify the defect within the specified time, the competent authority may cancel the lease and or levy a penalty not exceeding rupees 50. It is only provision available for cancellation of the lease. Now today you are admitting the sub-collector is not the competent authority, and the same sub-collector is cancelling my lease. That is one. Two, if a lordship would see the lease deed was executed in my favor, a right is accrued in my favor. Now, not relying on that principle, those principles may not, the judgments Pulin Bihari Das, Gokharaju, State of Telangana, 2019 SEC, these judgments are all there, which speaks that even if authority has no jurisdiction, in furtherance of that, he has conducted some official act.
No, that de facto doctrine applies there in a situation where a authority has exercised his jurisdiction and thereafter later on found that his holding of the office was found to be improper or an illegal. Then whatever action which he has taken,
they are all saved
on before that, they are really saved by a doctrine of de facto.
But
De facto
the same thing as on
the factum valet doctrine that really comes into play.
That is what. But then out of these two principles, people actually would kindly see, admittedly sub-collector did not have jurisdiction even to cancel it. As on the day when we are passing this order.
No, Mane, according to you, the sub-collector was a competent authority to issue an auction notice.
But if your lordship sees RDC's order, that still holds the field. RDC order has not been recalled as on date. Kindly see that.
No, you just said that sub-collector was competent.
In 2004.
No,
right. In 2004, when he issued the auction notice, he was competent.
No.
Then
2004 got repealed in 2016.
Okay, when he and he floated this in 2020.
2020.
18 man auction notice.
Auction notice 2nd of November 2020, page 18. 2nd of November 2020. And this is basing upon the letter issued by RDC, page 70. RDC, who is the head of the revenue of the district division, he writes to collector and district master at Khurda, where the mines are there. In inviting a reference to the subject cited above, I am to intimate that that necessary step may please be taken for auction of queries of Lord Jagannath situated in Khurda district for financial year 11-12 through competent authority as per OMC rules in terms of 2004 rules, where the sub-collector was the competent authority. He has written like this. But maybe in the pretext of this 2004 and this, where sub-collector went on conducting also, not only this solitary case, almost 20 or 25, 64 queries like this, sub-collector has conducted up. And all of them are operating. They were operating it.
Until that consent order comes.
Yes. Until that, thereafter they. Even after the consent order, they have operated, including the petitioner. Post, as my lord said here, post action.
The other rate petitions are also there, which has not been listed today. But, they all listed together. Similar issues.
notification. Kindly see page 5 of this notification. Page 5. Page 5, Schedule 4, refers to the Rule 28, the enabling provision. Grade with Rule 48, page 5 of this Gazette notification. Specified minerals.
After it is completely ousted from.
Yes. Revenue outstate, sub-collector outstate, Tahsildar outstate.
We are in 2016. In
Yes.
2016, he said that again it came to Tahsildar.
2016 Tahsildar was there. 2022, it went to the mining department, deputy director, and the sub-collector is passing order in 2025. Mining this one. The mining officer. Serial number 2, query lease and query permit, mining officer of the respective jurisdiction.
It has transferred.
The pattern it can be done by the mining department.
Not interested in going so deep into the de facto doctrine.
Right.
That
I have understood.
It will create a.
That may create. Well, I am on the point of jurisdiction. But my instruction is government is now reviewing the whole issue. All these queries, government is reviewing the entire.
What is the stand of the government?
I think it's this.
That's it. Maybe a wrong, right, whatever. Once the power is transferred on the mining officer was within this completely state that it is a wrong one. Hereby cancel.
But the only reason mentioned in the order itself.
No, reason may be valid, certainly. There are two aspects. The authority exercising the power is to be considered at that point of time.
No, Temple has filed a counter affidavit which I do not have. I'm not. What did he wants to say something that I has done.
Well, I will hear him. First thing is, when I was sitting with Justice Raman, we have already said, after the transition, now the mining department can take a call. Yes, but not the Tahsildar. Similar, that is the last point he says, that yes, rightly, wrongly, let us proceed to the greatest of height, that this lease deed was absolutely beyond the purview of law. But who can cancel? It's a competent authority. On a particular day when he wanted to cancel, whether he can assume the power, can be cancelled by. Being officer is not really deterred by any kind of a obstruction. Now can he assume? Now I will hear, he is very energetic, we will hear this point. Forget about the de facto. Now you
But no notice also.
tell me. Okay. How can a sub-collector cancel the lease deed after the transition of the entire power into a mining department?
Yes, sub-collector has not cancelled so much or its own jurisdiction. Only carry forward the judgments of this honorable court.
I am simply asking, sir, a judgment has been passed. The judgment is supposed to be communicated, let us hypothetically say, communicated by a chief justice. It is communicated by a peon of the office. Can it be said to be a proper communication? Must. If the statute says who can communicate, if somebody else communicates, is it a valid? Cancellation is the main issue. Who has cancelled it? It may be wrong. It was a wrong lease deed. Let us go to that extent. But cancellation has to be done. Who can cancel? On that relevant point of time.
Sub-collector was having jurisdiction.
Because it has already gone to a mining department.
Sub-collector has executed the lease deed.
That's wrong. Let us proceed wrong. Having no value, then you need a cancellation. Who can cancel it? It's a registered lease deed. Registration is
why
not
it has to
cancelled.
be-
Registration is not cancelled, my lord. Only by letter.
Because then I have to learn many.
My lordship,
What is the difference between an execution and registration? Now, let us go to the very fundamental point. What is the difference? It's a registration is not cancelled. Then what is cancelled?
Lordship, kindly see the cancellation order first.
I am asking you what is cancelled themselves. You are taking me to a very basic question.
What I will cancel,
No.
kindly see.
What is cancelled? Deed.
Lordship, kindly see.
Let us see deed.
Yes, ma'am. Cancellation of notice inviting tender for auction of the subject matter. The minor mineral sources of a SGTA and consequent cancellations of
Who can cancel it, sir? I am asking.
Yes,
A auction notice has already been implemented. The consequential steps has already been taken. Then what is cancelled?
Last quote one paragraph. Lease is
Lordship,
kindly see. Lease granted in your favor.
whereas a notice inviting tender dated 7/7/18 was issued by sub-collector from competent authority for auction of 34 minor mineral sources belonging to Sri Jagannath Temple administration. And whereas the authority of sub-collector to act as a competent authority under OMC Rule 16 for conducting the aforesaid auction was challenged before the Honorable High Court of Orissa in writ petition number 13424 of 18. And whereas the Honorable High Court of Orissa by its judgment dated 20th July 22 has been pleased to pass the notice inviting tender dated 7/7/18 on the ground of lack of authority, rendering the said NIT unsustainable in law under the provisions of the OMC Rule 16. And whereas you are declared the successful bidder for the Dangarpada new building stone quarry, and the lease was accordingly awarded in your favor by this office letter number 8925/16/18 as per NIT dated 7/7/18 issued by the sub-collector from competent authority Khurda. Now therefore, in due compliance with the judgment of the Honorable Court of Orissa, writ petition number 13424 of 18, and in accordance with the provisions of the amended OMC Rule 16, the lease granted in your favor in respect of Dangarpada new building stone quarry is hereby cancelled with immediate effect.
So what is cancelled is? Lease deed.
Lease is cancelled.
Can you? Question is very simple. Any. Who can? Is the mining department.
Mining department has not, my lords, at that relevant time was not the competent authority.
Interesting.
Now, at date of cancellation is
I am asking what is the date of cancellation?
the date of cancellation is May 25.
Then
Post-
mining
post-
department, everything has been transferred. Power is transferred. Who can cancel it? With these riders, with this finding, one can cancel. But who is the authority who can cancel?
As per the new amendment rule, means competent authority.
When on a day when you cancel these deeds, can you visualize the situation? Then in that, on that day, the authority must have the jurisdiction and power to do so.
Now the position is, my lords, again, collector has also cancelled all the lease in view of this judgment. No, sir, you cancel has all the blasting permissions, my lord. So none of the mines are now, my lords, operating.
That is a separate issue.
So, this is of this judgment, this is basis of the judgment only.
Question is of a
Now,
cancellation.
competition.
We are more concerned on the cancellation. We are concerned.
He assumed to
Because
use only to 16 years.
My brother was not a part of that, but another guy was a Oh, then my brother also, we have said that on the particular day when you have taken a decision, whether you were a competent authority. Then you have to know. If it is not, it's not.
If that is so,
Let us proceed. That was the lease deed which contains several terms and conditions. After that particular transition from Tehsildar who executed the lease, now it has gone to the mining. The mining officer found there has been a breach of the terms and conditions. Can the mining officer not forfeit the lease, cancel the lease, terminate the lease on the ground that you have violated the terms and conditions? If he has that power of forfeiture and the termination, then he can exercise the power of cancellation as well. You can't assume. What has been done wrongly, you can rectify it because now we are
mining officer can do.
can't do it. That has to go and now you have become wise, you know what to do, the state. And by virtue of that High Court order,
Yes.
this particular auction notice was.
No, this was never the subject matter.
That was judgment in rem matters. Totally NIT was challenged and interim order was there also.
Do not invite me to go into this. If it is a consent order, I do not know whether it is a
Judgment in
That's
personal.
not consent order, my lords.
Sir,
It was
you must.
Bori was whether the statute provides.
In rain,
The council said it is yes.
please, a judge, you must know the distinction between judgment in rain and judgment in consequence.
Yes, this is my entire NIT concern. This is applicable to REM, though one person has challenged the tender.
Consent order.
Consent order is in rem.
It's not a consent, my lord. So Cody was asked whether this is the correct position of the statute. It's yes, correct. And then the statute provides, my lord. So where is the consent? Law is the authority law.
Yeah, it's a large debatable point you have raised. We do not want to go into that aspect. Just give me that relevant dates.
Yes, please. The auction notice dated 2nd of December. It's there. Auction
Your
notice.
petition is also there.
Well, it was not listed today, Malad, similar matter. Malad, similar writ petitions, your lordship was kind enough to issue notice.
Listed at 2 p.m.
You can. No, but
My matter is listed
yes.
tomorrow. My matter is listed tomorrow. That may be
It
taken.
is listed tomorrow or going to be listed?
No, it is listed tomorrow.
This will be listed.
In the weekly.
Yeah, it's already been published.
Yes, it is published for the entire week. We know.
In this matter, then tomorrow, let it, all these three matters. There is any other matter?
we believe there are other matters, but
There are other matters also,
Yes.
batch of matters. All have challenged.
Yeah, around 30
I have
queries,
already given the list.
30 queries were
No,
cancelled.
no, let us then decide one and then there are.
That will be fair. That good enough.
That will
Yes.
follow.
Yes.
as your lordship is.
Give me the relevant dates.
Not bad.
Date of auction, just in a sheet of paper.
Yes, Mr.
Date of auction,
Yes.
the date of declaration.
Yes.
The date of execution of the lease deed.
Yes.
Coming in force of the provision of 2004 rules, permit the sub-collector above the value of 50,000.
Yes.
Is competent authority, yes, give that. 2016, Tehsildar, that is a part. Then in this 2022 amendment, where it is transferred from
Give it.
Tehsildar.
During lunch only, I'll have it.
Give these,
Yes,
those facts.
I'll give it during lunch period, but no.
Only the facts, please. No, give it to me. During the lunch, we just gave, but after lunch, I dictate.
Yes, sir. During lunch, we'll have it. Right, put.
Item 11.
Here me not sir. The query lease was for 5 years. Could not operate, however, my lease was cancelled by the authority. That was challenged before lordship. The lordships were pleased to uphold that. Of course, only one out. he said that it was challenged that the officer in charge, mining officer in charge cannot cancel. But Lordship came to a conclusion because the in charge officer has got the same power. So it's all dismissed. Subsequently, he made a representation Lords to consider for praise by invoking Rule 64. Innocuous praise, if you can let them consider reject their note. That is the prayer. On merit, I don't.
Cancel and the expiration are two different concepts.
No, I said not extension Lord. For praise Lord. Because I could not appear.
They have to go, they have to take it under, this is a query.
No, it's a morum query, Lord. It's not signed query, it's a morum query, Lord.
What is the query?
Yes, morum second, Lord. Yes.
27(1) will apply.
27(9) Lord. So it's not lapsing, but still.
27(1), yes, that is the grant of the query.
Yes, yes.
It will apply.
No.
Then
they will only consider my representation if they can, because I admittedly I did not operate for 5 years. No wife was issued. I did not deposit because there was no road. Even I have not paid the amount also. On that ground, they did cancel my list. That is justified loss.
they are justified by e-lottery now.
No, e-lottery notice has not yet come because it has been cancelled since. Look, that is obviously there not so they can deliver me. So I filed a representation and
Before is the situation where the cancellation, not the cancellation, expiration for a different period, he could not operate beyond his act. So here you have not deposited a single penny.
no, because I had a case before the cancellation because no road was there and the authorities knew, but I never raised that question.
When you apply, have you not seen?
Yes, no, that is why I'm not saying.
What is there? You should not have applied.
Right, no, I should not participate in looking at the topography.
You cannot say no road, no nothing. There was no objection that came.
But here, that is also not my case, but I never objected because cancellation is accepted. If they can consider, that is all. Otherwise, on merit.
I have a reservation for consideration of representation. Lot of reservations. Creating another cause of action for another litigation I have against that.
No, because two cases, lots of
If
time.
your right is there, I can understand. If I do not find your right, until they go, 27(1) says they have to conduct it in lordship.
Yes.
They will have to
No,
conduct
here it will not give right to face cause of action because lordships have made clear in the previous that you have not expressed on merit. It is up to the authorities to consider on the circumstances. No face cause of action will arise, even they reject also belongs. Because I have given your lordship two judgments where exercising power under 64 belongs.
No, that is what I said, that 64 can be, we say the state government can relax any of
Relax any provisions of law.
That is a different aspect.
Since the dues were unpaid, and it's because of that several demand notices were also issued, but he did not respond. Thereafter, the lease was cancelled. He was also informed that in lieu of his representation, that lease has been cancelled, So now when once e-lottery is held, he can participate and accordingly.
We'll observe that the event if they publish or invite an you can apply. You can apply.
If I'm prepared to pay all the demands they raised prior to this cancellation, if I pay, they can consider. If they can consider, I'm prepared to pay all the dues they have demanded prior to cancellation. Only ground is that I have not paid the dues for 4 years. First year I deposited, 4 years I never deposited because I took the plea that I did not operate. But that will not be a ground because that I have to, once I have executed the lease, I am bound to pay. If they can consider on payment of the entire dues, my friend can take instruction, they can consider. Otherwise,
No. That's
Date.
And for the next.
Madam, there appears to be a 3 books on 27/1 you are referring. One book says e-auction, one book says e-lottery, which is correct. I do not know. There are 3 versions. I got it. Which one is correct? E-lottery or e-auction? E-lottery.
Excite.
25 edition is correct.
Mining OMMC. Very interesting. 3 books are given to me and 3 different versions. One talks about simple auction, another talks about e-auction, and third talks about e-lottery. Which one is correct?
That is e-lottery.
Yes, sir.
But I have given the list of this.
Thank you. Well, I'll dictate the order.
So we
I'll
take
dictate the order. Yes, today itself.
Item number 12.
I think this one point is there, madam.
No point is there. All points are.
Lease deed also executed by the Tahsildar.
I know, that is what I'm saying.
First amendment.
The connected matters have already been listed. The connected matters are also listed.
Just give it. You are appearing in all the matters? Connected matters?
Notice has been issued.
Somebody has to be there. Somebody has to be there for the administration. Then it cannot be done. You just give a notice to the other side. Who is appearing in those matters? Supplementary list?
Is there in the list?
Is not there is a list.
It is not in the list. No, it is for state. Mr. Swai is appearing. For the Jagannath administration, Sri Jagannath administration.
20th of March, your lordship was pleased to issue notice. For which?
Who is appearing?
My senior appearing. In that case as well.
S.A. Swine.
Yes, ma'am.
S.A. Swine.
In both the matters?
They say, premier to detail. But I will still continue to check.
Yes, it is.
Check. Let me check it.
Sorry?
I have not checked the matter.
Check it. Keep it tomorrow. Check it.
Other matter is also for tomorrow. My matter is listed tomorrow.
Then this matter should also be listed tomorrow. Mr.
Yes, sir.
Roth, your matter is also there.
Did it come in the supplementary?
Supplementary tomorrow. First,
Well, I have-
1, 2, 3, 4, whatever.
Yes, but I am giving one more number, let it also.
Give. That is.
Item number 12.
Why you are not paying? Who is not paying? OMMC.
I have received the instruction.
OMC.
Kind turn to clause 9.4 at page 63.
Yes.
Clause 9.4.
Yes. In case of delay.
Delay beyond the total timeline and of shortfall in achievement of target caused due to reasons beyond the control of agency, penalty or liquidated damages may be waived subject to approval of the competent authority. In fact, there was certain delay as a result of which deduction was made. And after the closure of the contract, he has represented to the management that he had my difficulty as a result of which I could not achieve the milestone. And that is under consideration.
I would just point it out that
this is my instruction.
No. Is there any communication that they will release the fund, whatever?
yes, my lord.
Where is that?
So, my lord, refer annexure 11 series,
Page.
page number 140. The matter may be closed as per payment contract terms by next week. So, refer the top of the page, my lords. The petitioner's representative sent an email that these much amounts are pending under the invoices. At that time, the amount
No,
of.
no, that you have written a letter, the email to them.
Yes.
What is their response to this?
In response to that, my lord, the CGM Geology, Bharat Charan Sahu, he has written the matter may be closed as per contract terms by next week.
Where is that?
Top of the 140 page number, my lord, right on top.
Yes.
The email starts from the page before, the email header, 39, right at the bottom, from Bharat Kumar Sahu, Bharat Chandra Sahu, December 5, 2025, my lord. He writes, the matter may be closed as per contract terms by next week. Thereafter, my lord, there is another communication of February, 17 February 2026 at page number 148, my lord. Here again, Mr. Bharat Chandra Sahu writes, hi David and Gaurav, all the due payments will be cleared in this week.
So there you have admitted.
So that is under consideration, I have said.
What are you talking? That consideration means if you have admitted, yes, it will be cleared in the next week. Then what?
So that is after approval by the management concern that will be released.
What management?
That is clause 9.4. Yes. It provides that the explanation for the delay regarding penalty may be.
Who is the competent authority of OMC?
That's the management.
What management?
Tender Procurement Committee.
Have you ever raised any penalty?
Yes, it has been imposed in course of execution of the contract, plus certain amounts are recovered towards penalty.
That you have already recovered?
Yes, then he claims that amounts should be released in his favor.
No, he is talking about the other bills.
No, that is the issue.
So, firstly, there is no delay, my lords. If I turn, if you can look at page number 40.
I tell you very frankly, I am stuck by my own judgment.
Yes.
So far as the writ jurisdiction is concerned, if there is a complexity in deciding a particular thing, then the court will not interfere under Article 236.
Protect your own judgment.
I have said so. And therefore, if it is an undisputed one, then definitely the writ court will direct them to decide.
Not issued one single communication where they have imposed or threatened to impose liquidated damages at any given point in time.
So that is what I asked, whether they have imposed, they have quantified the penalty or something of that kind.
My lord can see my instruction, my lord can see.
I am not concerned about the instruction. Where is your correspondence? Tell us that where you have imposed a penalty and communicating to him that by what this amount has already been deducted from the on account of penalty.
File affidavit.
What affidavit?
Well, indicating that which of the amounts have been recovered.
Have you ever communicated to him? Not a single communication is forthcoming.
All those details I don't have. I will file affidavit.
Take an instruction and give it to me whether you have made any correspondences regarding the penalty. Yes.
My lord, there is interlocutory application also. So, my lord, apart from the
what is the interlocutory application?
So, my lord, they also have. So, there is a performance bank guarantee that was issued at the time of entering into the contract. The performance bank guarantee was for a period of 3 months after the contract period ended. The contract period ended in June of 2025. In August, when the performance bank guarantee was supposed to expire, they sent an email that please extend, otherwise we will invoke. So we had to extend. Again, the last demand notice that we issued was on May 25th of 2026. Again, we issued them a demand notice, pay our dues. Again, the very next day, they issue us another email, extend again, or we will invoke. Now, the performance bank guarantee in terms of the agreement clearly says that it is to secure the performance and will subsist only 3 months after the contract period are done.
So why you have extended?
My lords, they are in. So the performance bank guarantee states that it can be invoked at any time after its expiry for 12 months. So they are at liberty to encash it at any given point in time, and their written communication is extend or we will end.
What is the law? What is the law of injunction on the bank guarantee?
My lords, this
what is the law of injunction?
This very court, my lords, has in
what the Supreme Court has said?
Yes, Jindal's in.
When and under what circumstances the court can injunct?
So, my lords, we are not asking. So, there is no prejudice that is going to be caused to them. Special equities exist because
you are talking about the interlocutory application.
My lords, yes.
I was simply telling them to take an instruction and come after 2 days.
Okay, my lord. Much obliged.
When you talk about the interim, then you'll have to satisfy the law. The writ petition.
Item number 13.
Well, after this honorable court has came to a conclusion that the state is wrong by not regularizing the petitioners from the date of their initial appointment. At the same time, the state has been favored with equity. That this is the
Is this a ground? Is the error apparent on the face of the record?
Yes.
Tell me, is it error?
Well, everything was on record.
No, I am asking, a decision is taken by a court.
Right.
The court is within its discretion whether to grant all the actual financial benefit from the date of the initial entry, or to grant a notional benefit, or not to grant any benefit. If it is within the discretion of the court, does it come under the error apparent on the face of the record?
That what your lordship proposes, that is not
Then what is the ground?
My lord, may kindly see page 30.
What is the ground? I am looking at it.
When the tribunal found the stand of the respondent, department be defective. Be defective.
13
Page
page.
13, last paragraph I'm reading. When the tribunal found the stand of the respondent department to be defective, it would not have been denied full relief to the petitioner with effect from the date of their entry into the service.
Correct.
This is the view of this honorable.
Correct. What is the full benefit?
Full benefit by regularization, CDR.
That's all. Full benefit of regularization and the continuance of service.
Yes.
From the date of their initial entry. That's all. That has been granted.
Well, thereafter, what be that as it may, years have been rolled. Now, some equities have to be worked out for the government also as rightly contended.
The equity is not a one-way traffic. Equity must be given to both the sides.
That is correct. But the law is that wrongdoers cannot be covered with the equity.
No, sir, you are wanting to re-argue the matter, which is not permitted. Sorry.
Not saying anything else. I'm not saying anything.
Since you are an author, you should conclude it.
My lord, through judgment that my lords have passed recently.
I know. Give it.
And I also.
Yes. Have you read the Tungabhadra's judgment of the Supreme Court? Yeah, 1968 probably. No, not that. Tungabhadra. That's the one of the.
Yes, Murli Sundaram cases.
Yes. Have you gone through the Ashok Rupahura judgment of the Supreme? Have you gone into the Maleshwari judgment 2025 of this court, of the Supreme Court?
I have gone through your lordship judgment while sitting with Honorable Justice Raman.
Yes.
And delivered the judgment in that Ranjan Kumar Rao case.
Yes. What I have held?
That with regard to the benefits and denial of benefits is wrong.
That is the I am again saying that if it is within the discretion, if one way or other a discretion is exercised, then in that event it does not come under the purview. It may come within the purview of erroneous judgment, but it does not come within the purview of judgment containing an error apparent on the face of the record. Sorry. Give it. My brother.
You file it.
My brother.
You want to file this decision?
Yes.
Give it.
Item number 14.
Consolidated description filed yesterday, stock is supplied to the maintenance.
Consolidated as what?
This for orders.
Huh?
This for orders.
For orders for what?
Then he has complied.
Very strong. Is not
So it's in lockdown. So.
Huh? Then it has to be listed along with the consolidated. What is submit? They have not. It is not included. It is submitted by the counsel for the petitioner that the consolidated. And newly incorporated persons, have you served the copy?
Yes.
Yes.
Item 15.
The requisites put in.
Item number 16.
Your lordship? What? I heard your lordship appear for audience. I heard that your lordship appeared, so I was really shocked with that. I never appeared here.
Item number 17.
Despite my lord's previous order, this item number 1485 of 26 is not in this one.
Which one?
Item number 1485 of 2026.
It is submitted that I number such as. Sir, incomplete requisites.
No, I am appearing for respondent.
Copy has been served. Copy has been served.
Sir, why your advocate and record has not come submitted the.
Forgot to find the IA.
Oh, IA is not attached with the requisites.
Yes,
Now you are appearing.
I am appearing for the sole respondent.
Yes.
Read application was disposed of. I was a petition for single yes. The only direction has been made to consider. But that
Where is the impugned order? Where is the impugned order?
Page 70.
Page
79.
79.
I am appearing for the bank. My husband is the respondent, sir.
No, I am appearing for the
Sorry, yeah.
order is starts at the.
You are representing the bank.
I am
representing the bank.
The order seems to be very innocuous, but it affects the entire administration of the bank. Transfer to any. Replace it, your lord.
Everything is in your favor. Everything is in favor of a bank.
It's not a question of favor.
Is a challenge was made to what?
Challenge was made to
transfer.
Page 18.
Transfer.
Okay.
And they rejected that application. Then that order of transfer was again challenged because that is contrary to the policy. It simply the court said, the honorable single judge said, because paragraph 7.3 to give the in terms of that policy, they didn't get the join. They didn't first join there because that order of transfer was appealed. I joined there. Then, in fact, there's an agreement, a consent that you give the different choices. They would select. They will pass appropriate order. Paragraph 7.
Join in Jaipur branch.
Yes, I joined.
Honor before first May.
Yes, sir, I joined.
And thereafter to represent and to.
Yes, sir. Yes, that is exactly.
Order has been complied. Direction has been.
So you were transferred to Jaipur.
Jaipur.
Okay, by them.
By them.
So you have been directed to join. Now you have joined there.
No, joined. I made the representation. They have been directed.
Joined on 29. Joined 30, on 30th, she goes on leave. That is another matter, my lord. He is on leave till today. My lord, pays 34 year old.
No, after joining.
After joining, she is on leave. Before
you have granted a leave. You have granted a leave.
No.
So you take an action. You may take action. If it is an unauthorized absence without any sanction, you can take an action.
Why I am questioning this order of the honorable single judge, my lord, is at page 7.3. Page 84.
Correct. I am looking at it. It is, however, observed.
On her joining at Jaipur branch, if the petitioner makes a grievance of a transfer to any other place nearby to an earlier place of posting, by giving an option of three choices, opposite party number 2 shall favorably consider the same and pass an appropriate order within a period of 4 weeks from the date of issue.
Correct.
such representation.
Correct.
However, it is observed that petitioner shall not give any option for her posting either at Cuttack, Bhubaneswar or Chandigarh. Now let me give a pause on this here also. I am really, my lord, what I am aggrieved about, I have transferred her perspective page 34.
Where? Yeah, Jaipur?
Jaipur.
Go, let him go. He has gone and joined, or he or she? She has gone and joined.
Let her join and continue.
See, she's continuing. You continue. Continue. Only thing is the representation has to be considered. It does not say that you'll have to transfer.
It doesn't say, my lord.
So you can reject it, you can allow it, whatever you want.
First time I rejected.
You will observe. We will observe. It is within your authority to decide whether to allow any transfer. Prayer is to be rejected, reject it. Whatever you want. Where is the difficulty?
And also, your lordship may appreciate these three places are all nearby Cuttack.
That is not said in the
That is why I say the Cuttack you will not. Rather, they should be aggrieved that in future, if you want to transfer her in Cuttack, then you are prevented by this order not to place her.
My lord, this observation really, this entire administration of the bank, because he was punished in a departmental proceedings.
Is it a punitive transfer?
My lord?
Yes. Why are you not challenging that order?
Order has not been challenged. Order is never challenged.
We have challenged that, sir. That cumulative order of transfer was challenged, and this the honorable single judge passed that order. Not to that order.
Sir, if it is a punitive transfer, then the question of natural justice will come.
Yes. On that ground alone, it should be questioned.
Page 84, 7.2, your lordship will check. Page 84, 7.2. However, considering the fact that such an order has been passed by revoking the order of suspension, this court, while not interfering with the same for the present, directing the petitioner to join.
This is what I'm saying. So the court has not really accepted that it is a punitive transfer.
Yes.
So why you are saying punitive transfer? Wow. That's why I say you should be thankful to the judge.
Then this contempt came. Contempt is to comply within 4 weeks. So that has expired.
Have you considered the representation?
Then second,
The representation after joining, you have not.
They are not considered.
So we are, for you, we are directing you to do it we can modify the order, there is no difficulty, as an appellate court, but not as a contempt jurisdiction. No. We can extend the time to,
That can be.
as an appellate court, we can,
That's it. That's it.
lordship, I
Only the time should extend.
but not in contempt.
No. That contempt only for the honorable single judge. That is the difference.
No, even in contempt, I can't.
That's
Can't.
it. That's it. Lordship only can extend the.
your lordship, we have challenged it in time, this matter, my lord, on 17.5 we challenged it, your lordship.
So we can extend the time for disposal of the representation.
And we can allow or we can reject.
That we can, that is within your competence. That is within your competence.
Primarily, what our my lord objection is, we feel, the bank feels that this sort of order, my lord, might affect the morals of the others. Reason being, my lord, reason being 3 persons were penalized in this.
I understood the actual, what is passing in the minds of the authorities.
This might become a precedent now.
Four weeks was given, much 3 weeks.
So no 19.
In item number 19, you could kindly see, there are 3 matters where the Tata Steel is the.
Can I?
In the petitioner.
What
is this matter? These are the matters.
These are the matters covered by your lordship judgment, my lord. That 12.
These are already, permit me 1 minute. Yeah. That yesterday, in fact, one matter which your lordship recused to hear was before court number 1. The state is already in appeal. Lord, your Lordship remembers where that validity of Rule 12A was under challenge and the demand with regard to the minimum production and dispatch, 7 number of SLPs have been filed within the period of limitation. Lord, the Honorable Apex Court is already in session over the matter. The same submission being made before the other coordinate bench yesterday. Dr. Singhvi was also there. Mr. Rath was also there. Matter has been posted to 9th of September. We have moved also an interim application. Lord, crores of state's revenue is involved. It is not simply covered. Factually also it is first year demand. So therefore, my Lord, I am praying that let the matter wait till it is being taken off in the numbers I am giving. 7
Now, my lords, can I say something before the numbers?
Dr. Singhvi, you should be fair. Yesterday you made the same submission before Justice Pathak's court for
Sir,
JSW.
allow me to be
The
judge
court
of
was
my
fixed to
fairness,
grant
please.
adjournment. No,
Allow me to be judge of my
maybe
fairness.
allow, but let us be
Yes.
fair with the
But
court.
may I say
Same
something?
submission, there is.
May I
We are
say-
already appeal.
I am
We
the
have-
petitioner, my lords, if my learned friend doesn't mind. If he doesn't mind. Now, my lords, I am addressing your lordships. I am addressing your lordships.
Revenue is involved. I have to be naturally.
I
You submit.
am addressing your lordships in writ 23847 of 21 and writ 19641 of 21. All that I am saying is this. My learned friend in court has a note, a very short note, which shows that there cannot be a judgment which covers my writ more than the judgment delivered by my Lord's bench in April of this year. Point number 1. My learned friend, the AG, is entitled to argue to show why it is not covered. I'm not objecting to that. Secondly is very important. What my learned friend, the AG, is arguing is not why it is not covered like a glove, but that a April judge, Lordship may hear this, fellows, an April judgment by your lordships, not listed in Supreme Court as we speak till 4th August, should be reckoned by your lordship. Can I finish? Can I finish, sir? I didn't interrupt you.
So why are you
Mr.
making
AG.
young submission? The
I
very
did not-
same
I did not-
submission
No,
you
no,
advanced
Mr.
I did not interrupt you.
Mr.
You can't interrupt me. I'm
Mr.
sorry, Mr. AG.
Mr. Advocate General,
You can't interrupt me.
what he is arguing is
Allow me
never
to
says
finish
that
at
it is
least.
not filed. He
No, no,
says
allow-
never listed till
Yes,
4th
allow
of
me to
August.
finish,
No,
Mr.
but
AG.
it was
Don't interrupt me.
filed last week in the
Yes,
period of
filed.
We are
He
not
is
talking
not
about filing, Mr.
disputing. He is not disputing that it is not filed.
Milord, it is a.
Either he's not hearing, Malus, either he's not hearing.
We filed it within the period of limitation. Supreme Court, your lordship knows it
Now,
was
Malus,
filed on
allow me to
20th of
finish
July.
my statements. Allow me
Let
to
him,
finish.
that's the irony of the virtual hearing. That's the whole difficulty. What
No,
can
no,
we
Malus,
say?
there is no difficulty if an doesn't interrupt like this. A, he's interrupting. B, he's not hearing what we are saying.
No, I understood you say that those these SLPs have not been listed as on 4th of August.
4th of August,
Yes,
number 2.
yes,
Number
yes.
3, he is arguing that there is auto listing and auto stay without the matter being listed. And your lordships should not therefore, your lordship should therefore, your lordship's order is not stayed. Your lordships is not stayed or listed even after 4 months. Why is it not possible for my learned friend to carry one more SLP to the Supreme Court in the event my lord disposes of this SLP in terms of the order?
Is not that rich,
In
like
terms
you
of the
want.
order.
Private
And
client.
yesterday's order
afford to have
has
25
simply
lakhs
adjourned the
with me
matter.
per day.
That is a matter which went as a single matter because your lordship were recused in that matter. Otherwise, the batch is here. All I am saying is that was a matter which is not in any manner fettered. He can carry an SLP from here in case he finds that your lordship judgment covers this.
Why should I go the very same question that is already
I'm appearing in the
It was
I'm
filed a
appearing in the
fortnight ago
accompanying
within the period
writ
of
petition.
limitation.
Milord, I'm
Within the
appearing in
period
the
of
accompanying
limitation.
writ petition. May I also just request, Milord, that what we are seeking today flows from the order itself. And once the order has a direction that it is not retrospective, Milord, and the demand they've raised is retrospective, the consequence has to follow. It is self-operating in terms of the directions my lord have given in para 182 and 191. So, Milord, irrespective of a challenge, My lord, my learned friend will allow some of us also to address the court. So we are saying, my lord, that once para 182, 184 and 191 covers the fact that any demand which is retrospective, my lord, is illegal, then, my lord, the show cause notice and the demand have to fall. It flows from
That
the
is legal
judgment.
or illegal, this not the states
So,
to
my lord,
decide.
we are only requesting that that which flows directly from the order and the judgment given, of which there is no impediment today in the absence of any order passed by the apex court, your lordship will just apply that principle in my writ. So three prayers are challenging a demand which is retrospective. It is for a period from June 20 to June 2021, my lord, which is prior to 1/7/2021 when 12A was inserted. So I'm only asking for disposal of this writ in terms of my lord's judgment, and three paras covers it: 182, 184 and 191. 191 expressly does so, my lord. That's a humble
May I
request to the
intervene,
court.
Milord?
If I have given a little
Milord,
chance.
the judgment, your lordship may kindly permit.
Provided you get a chance.
They let them complete through VC pass. Otherwise, we physical people will always lie back. Let them complete fast.
There's one sentence interruption. I have a one-sheeter, 1.5 sheets, which gives the findings of your lordship with the para numbers. I mean, anybody has to see that 1.5 sheet. The findings are clear and crystal clear, Manoj. Right or wrong is the Supreme Court to decide.
All that Dr. Singhi and Mr. Jain, Senior Counsel Mr. Jain say that, but to supplement all of them, this case which are on your lordship board today are covered by your lordship judgment after steel case. What your lordship have been pleased to hold there, your lordship has been pleased to hold there. The amendment 10/6/2021 is prospective, it is not retrospective. 1, 2. So far the first year demand is concerned, it covers under the moratorium clause 12A1C. 12A1C.
I still remember that.
Yes, no, that is first year demand. It is exempted under moratorium provision. So far as this third, fourth, and fifth demand are concerned, your lordship has been pleased to hold that the proviso to rule 12A2 proviso, since do not bear any penal provision. Since do not bear any
It's a
penal
directory nature.
That's right. But this is all the case about, and this is the same case, we not tailor-made judgments. Only we seek for a mirror order to be passed by your lordship in these cases too. That's all.
Not a mirage.
Mirror.
I say mirage.
No, mirror.
Now, a learned advocate general will say mirage.
Let the first one demand is 600
and today's matter are all first year under operation of law. They are banned. Today's all these matters are for first year and are under operation of law.
Whether
those lordship rightly or wrongly have decided, the state.
No, definitely. Any decision has to be tested by going to a higher court. Definitely, there is no difficulty.
That's correct. So therefore, my lord,
these are all first year
period of limitation, notwithstanding ordinary.
Why should these matters wait?
This improper is not proper.
Can all of you give us just 1 minute? Can you give us one minute? Let us, my brothers, let me discuss with my brother.
ये क्या चल रहा है? 78.
Total demands in respect of this surveyed.
take it. This macro.
That's the reason I have been telling you. Your Lordship.
Now they have gone.
Right. Lord, my humble submission would be, now that there is no law that if we are filing up an appeal, will arrest your Lordship and dispose of the matter, since it is completely covered by your Lordship. And these writ petitions are even not even judgment. The provisions of law say that.
Stuck by our own observation in one of the judgments.
But your Lordship has also given converse observation in other cases also.
Your Lordship knows, your Lordship have always paid highest respect to the judicial discipline and propriety.
And I did not remind you of Atmara property. I did not remind you.
May I request, may I request my Lord friend
Filing
to
of appeal will not operate as a state.
Not state
Yes,
revenue.
state control. State control. The position of law is this. Position of law is this, Miller. Here, filing of appeal will not operate as a state. And see, what is the issue here? In Tata Steel, my lord, the issue is first year. It covered under the provision of law itself. Not even your Lordship. Kindly see, moratorium.
It is covered by the Lordship. More is happy.
Well, at best, in worst case scenario, Lordship may kindly consider. In worst case scenario, SLP's notice is issued. But can it be stayed? Because stay will amount to allowing the SLP itself. Demands are
That is, we can't make any.
No, we are not prejudging that at this stage. I have not said that.
In my Lord's judgment, your Lordships have already quashed the demands in that case. We are only asking for same relief to be passed in our writ petition. That order has already been
And
passed.
this is for first year.
Quashing the illegal demands.
Lord, 17,000 crore revenue involved. Lord, that too, the state is well.
We will also get a chance to address our point there before the Supreme Court.
Yes. I can't afford to have that luxury of putting 25 lakhs for a hearing.
Thousands of thousands SLP. State cannot
Cases are gone as a test case. If your Lordship's judgment is upheld, it's fine.
That cannot be.
I filed within the period of limitation.
Whether it will be
10 days have passed.
When you are expecting the SLPs.
Fairness demands. Your Lordship,
Mr. Advocate General, when you are expecting the matter to be listed before the Supreme Court, the SLP.
Yesterday, one such matter which your Lordship refused to hear, that was before my Lord Justice Pathak's division bench.
No, you are talking about a special litigation.
One minute. Yes. Very same, my Lord, the very same matter which they claim to be covered by your Lordship's Tata Steel batch cases. The very set of lawyer, Dr. Singhvi, Mr. Rath and a set of lawyer, they tried to persuade the court that pendency of SLP doesn't arrest your Lordship to proceed and pass similar order. His Lordship's bench was, my Lord, pleased to grant time till 9th of September. JSW matter is come to 9th of September. There should have been all fairness, my Lord, submitted to your Lordship in the beginning that a coordinate bench has already adjourned the matter to 9th of September. Your Lordship should pass this same order. They have started arguing before your Lordship that your Lordship would pass the order, etc., etc. I don't
Are you serious? Are you serious, Mr. Advocate General, on laying this proposition? That simpliciter adjournment by a coordinate bench will have a precedential value on the another coordinate bench?
I'm not saying that, Lord. My submission is state has preferred a set of appeals.
No, that is why I'm asking you what is the expected time when these matters can be listed.
A month's time, Lord, reasonable a month's time. Your Lordship may call it.
What are you talking? When you have gone and when you have filed this special petition?
Milord, on 28th, judgment was in April 20th, 90 days period. Milord, your Lordship knows in states appeal, ordinarily they file it after 1 year, 2 years also. So Milord, 90 days time is my limitation. I filed within that period. It is also mentioned before the court to get it listed.
I am also aware of that 2026 order or a judgment of the Supreme Court also.
2026, which is
judgment of the Supreme Court also.
Yes, madam.
Lordship passed the judgment on 20th of April. They filed SLP on 4th of August.
We filed on 20th
within the period of limitation that you can't say. Even on 89th day or 90th day, they are within their.
Yes. limitation.
But there is no law
Numbers
that
I have already given Mr. Tripathi, I think is holding the numbers.
I appreciate it. For the first time, you are just calling us. We are fixing this matter in the next week.
Right.
But we'll have to ensure that something happens, Mr. Advocate.
Right.
That 1 week, how can it be done in a week?
One was sufficient.
You will be getting a Friday, you will be getting one Friday and one Monday.
No, Milord. No, it is not possible, Milord. At least a fortnight time should be granted.
No, next week, let us see what progress is made. It is submitted by the learned additional guy, sorry, it is submitted by the learned Advocate General.
Very grateful.
One second.
Next is
One second.
too short, 7 days time.
Next Tuesday is 11th. Applications pending.
What is
For
it?
substitution.
Supreme Court, they have given a 15 days period at
Substitution
least.
means what?
Get the matter.
Lord, yes, the holding company, there is a merger of the subsidiary company with the holding company. Tata Steel Mining is the subsidiary company. It has merged with Tata Steel Limited by order passed by the NCLT. That order is also part of
The scheme of merger has been allowed.
So only interim application
Yes.
to substitute them
Okay.
on the call.
It-
Bring them on the call. That's all.
Well, is your lordship, can your lordship consider Wednesday the next day or just Tuesday?
Tuesdays are normally for these mining matters.
Very well.
that's why
Whatever is your
But then
lordship.
next Tuesday, Milord. Then let it
No,
be
no,
next
next.
Tuesday.
No, well, we are in urgency, well.
11th of April. 11th of
Can
this
it be,
month.
at least I should get some, Milord, I should get some miscellaneous in Supreme Court. Is to your lordship, ordinarily they
Come,
take
come.
15
If
days.
you are in difficulty, we'll see to it. Come on.
Miscellaneous matters will
Next. Miscellaneous matters. I think those can be allowed if it is their application.
come. Flag E, they are there. Flag E.
I think, Mr. Advocate General, these are very formal in nature.
No, that is not. I will examine, Milord. I do not know what is the application. I'll file a
Application is that the appellant, the writ petitioner, by virtue of a scheme of merger approved by the NCLT, has now merged with the, and there is a judgment of the Supreme Court that it becomes non-extinct.
Let me go through it. I do not know what is the application.
I can assure my
I think
learned-
1980s judgment, Mr. Singhvi.
There is a name change, Balaz. My learned friend should not even talk about it. There is a name change.
Why?
Yes.
Am I
No, there is a judgment of the Supreme Court probably in early 80s which says the moment the merger scheme is approved,
Yes.
then the company or the transferring company gets extinct.
Yes, the whole meaning is absolutely.
everything may be correct
Identity.
if it is-
Identity is gone.
Yes, that is what is apex court says.
Exactly.
Whatever, let me go through it. What is the application? Should I not get an opportunity to go through the application?
Much prior to that, it is served.
Not the first time today.
That's all.
Because one application has been made, it is to be allowed automatically.
Substitution application, the
Should I
state
not get an opportunity to say a few words on this? Just now I
It was It was served when? I don't know when it was served.
What is inside?
Come on the
Should I
next
not
day.
say on it?
Yes,
Your
yes.
Lordship is giving which date, Wallace? Which date?
Yes, yes, 11th.
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 Very well. Very well.
Let your lordship consider for
Yes, yes,
it.
11th. Let us see. Yes. Yes.
Also, other than substitution will be considered.
Oh, definitely. These are very formal in nature. There is no difficulty.
It should not have an
Automatically.
Item number 20.
Company which is non-extinct, how can he continue with the litigations? Yes. Call the next matter.
Item 20.
Item 20 minutes, there are two annexures 1 and 2. There are two annexures minutes, which are in ODR language. Because if your lordship shall file an amendment application to bring the translated.
And they are very vital.
Minutes. One is the advertisement for one of the auction process. And the second is the advertisement in which the opposite party seeks and
It is also
both
not
of us
properly
participate in that process.
But they get it.
On the prayer of the learned advocate appearing for the you are for the petitioner.
Petitioner.
Every time, why?
But this is a particular matter. A lot of difficulties listed. He is supposed to get the leave till 2030 and he's been fighting the litigation from 20. And today, Your Lordship, hardly 3 years left. Your Lordship will see the order sheets. Most of the time, it's the state which is asked.
No, Mr. Tripathi, this call. If it is, they can.
Your Lordship is also very pressurized. I mean, this board is also highly pressurized. Your Lordship, there is a written note and a date chart on record.
No, petitioner is also corrupt times. Most of the petitioner.
Every time on your prayer, it has been a job.
One.
At least I can lay hand to 3 of such orders. No, sir, this can't be. This cannot go eternal. We'll have to. Look, this is the word only, which is very ambiguous.
Only for coming person. Only for coming person.
No. Then we will take up this week, anytime you say. I understand that you are not ready, but still tell me when, this week.
This week.
Tomorrow, Wednesday, Thursday, what?
When?
Tomorrow is a Wednesday. Tomorrow?
Yes, ma'am.
Tomorrow.
Number 22.
This is that umpire sampling matter issue. Here, where counter is there, we have also filed a gender cut. I hope the
I was serving the food. I haven't served the copy, let them serve a coffee. Finding bicycle.
we have taken up some of the 80.
We're doing it in course of the day. Right now, we're doing it.
Submitted that the order.
Item note 23.
Appearing for the opposite party number 4. Yes, my lords. If your coaches may kindly give me 3 weeks time, my lords, to file my counter. I am unable to my counter as yet.
My senior is on VC, your lordship.
Who is your senior?
I'm ready, your lordship.
But he is, sorry, he is not visible. It's only the green screen that is coming up. You can also notice the green one. This is green. Green. Where is Mr. Reddy? You can't hear.
Your lordship, he joined your lordship.
Can't hear.
There is some glitch.
I think there is a technical glitch. There is some problem. Anyhow, in 2 weeks' time, we are giving next one.
So 1 week, everything has been filed, your lordship. Only open number 4, your lordship has not filed the counter.
No, I'm actually the lessee. As of now, I'm operating there. I need 3 weeks time, my lords.
Oh, then next week. I understood. I did not understand that you are an existing lessee.
My lords, I'm the existing lessee operating.
So 1 week, next week.
Item 24.
Okay.
So I am for the petitioner, my lord. Last week I have been served with the counter. We need 1 week time to file the reagent.
It is submitted by you are who?
I am for the
Yes.
Lordship, in the present matter, we have filed the rejoinder matter. I'm serving the copy for the state.
Where is the rejoinder?
My lord, I have filed today. I have filed it today, my lord. It has not come on record.
Will file it today or file today?
Filed today,
Already.
my lord.
Submitted to the
Complete, my lord. I have requested my land senior to take it up next week. I have not gone to this.
A short question. Have you acceded to
Yes,
this
yes.
request or you have
I can never no to him. I can never say no to him.
Oh, then come on.
I was only saying that 1 week after, not next week. Next week I haven't killed it. That week commencing 17th elections.
On 18th. 18th. 18th.
No, 18th. The interim order to continue.
Oh, that is more. That is more important.
It's actually covered by a lordship judgment.
Item not 27.
Interim order to continue. Grateful.
Item 27, I don't, the declarant order. The law will find.
Yes, who is appearing in 27 for the respondent?
State.
I mean, state.
Yes, sir.
For the, who is appearing?
But I am for this one.
How can you go against the petitioner? Nobody would dare. What do you have done? We can go against Jagat Janani. And you have gone. At their peril. Oh. What is the matter?
Yes, sir. The annexure 1 is the infill order. Page 27, I know. Very places, man. And at least we have
Yes.
Yes, sir.
The power sample.
My lord would see that the discussion, the points of law which was raised before the revisional authority has not been considered, but rather a cryptic order has been passed. Merely on the ground that we have fought for the testing of the umpire sample. My lord. Lord, I'll take my lord to the.
So you do not want the power sample to be
My lord, that is my ignorance of law, my lord.
My ignorance means it says that if they have collected the sample,
Yes,
they
ma'am.
tested.
Yes, ma'am.
Then if you are not satisfied with that particular testing reports, then you can definitely ask for a part sample to be given.
But
But it is always taken. You go to a neutral place of testing.
That's right, my lord. But the rules is completely silent on that.
What are you talking about? The
Yes, sir. The rules only, your lordship would see.
Rule 10.7.
10.7, my lord. Before that, my lord. 10.5.3, my lord. My lord, there is a comprehensive mechanism provided for transportation of minerals under chapter 3, my lord.
10-5 Roman 3, my lord. This is yes, 2007. Chapter 3 deals with transportation of minerals.
Each sample shall be divided in 3 parts.
3 parts. And the first part, my lord, is to be tested by the lessee in the designated laboratory of the lessee, my lord.
Correct.
The second part is to be tested by the government in the government laboratory.
Yes.
But the proviso says that in the absence of the lessee getting the sample tested in his laboratory, or if he does not have a laboratory of his own, then it has to be done in the government laboratory. And the lessee, my lord, once the sample is tested in the government laboratory, thereafter, my lord, the lessee is permitted to transport the minerals. Had it been a case where the lessee would have tested the minerals in his laboratory designated by the government, the rule says that he is permitted to transport the minerals. But in case, my lord, I'll just read out, my lord. Your lordship would tell for yes, my lord. Your lordship would see Roman 3, my lord. I'll just read it out, my lord.
Yes, we are looking at
Yes,
Roman
my
3.
lord. Each sample shall be divided into 3 parts having corresponding identification number or code to be randomly generated the online system I3MS. First part of the sample will be sent by the lessee to a laboratory duly notified by the state government under Rule 2G. Yes, my lord. The second part of the sample shall be sent to the government laboratory. Dispatch of, this is important, my lord. Dispatch of stacks may be allowed under sub-rule 8 of Rule 10 on the basis of analysis report in respect of the first part of the sample submitted by the lessee. However, the higher of the above two analysis report shall be taken for the purpose of calculating all government dues and differential, if any, shall be paid by the lessee along with the amount as will be finalized during the quarterly assessment. The third part sample shall be kept as umpire sample in the custody and premises of the lessee under lock and seal for a period of 3 months for the purpose of analysis in case of challenge by the lessee within 3 months of the sample collection. Thereafter, your lordship may kindly see 10-7. After submission of the analysis report by the lessee and before the dispatch of the stack. Therefore, when 10-7 speaks about after the submission of the analysis report by the lessee and before the dispatch of the stack, during surprise check, any significant upward deviation in the grade of the mineral is observed, then the mineral transportation from the concerned lessee may be suspended. Resumption of transportation may be allowed after conclusion of inquiry, which shall be concluded within 15 days. In case of any dispute raised by the lessee within 3 months from the date of analysis of the second part of the sample, the director may allow analysis of the umpire sample at the government laboratory in the presence of the lessee and his authorized representative. If is satisfied with the genuineness of the dispute and on the representation of the lessee, the analysis result of the government laboratory shall be final by date. Well, there is a contingency provided. Yes, madam. Provided that in case the lessee declares to pay the highest rate of royalty as prescribed under the second schedule of the Act, stacking and sampling shall be dispensed as provided under Rule 5, 6, and 7.
That is what is there.
That is the
highest amount. Then,
yes, madam. So therefore,
is required.
The rules provide. Suppose in case the lessee decides to get the first part of the sample tested in his laboratory, then he is allowed to remove the minerals. And
provided there are other conditions which are attached to it. It's not an unhindered power that you can.
No matter. There is the rule is silent. Once the sample is tested by the government laboratory, my lord, and on that basis, I'm allowed to remove the minerals. So where is the question of getting the umpire sample tested, my lord? Had it been the case that if I would have got the sample tested in my laboratory,
it has already been done on the basis of a testing report of a umpired sample. Now they have raised a demand because it is found to be of a higher grade. They have raised a demand. What remains?
But the rules is silent. The rules are not prescribed. No, but the rule only provides if the only on the rule is completely silent on that. And what you could see, it is because of my ignorance. But I'm relying on the judgment of
what ignorance?
But my ignorance, because the rule is there is no question of getting the umpire sample test.
Law is a good excuse in.
Yes, but because
ignorance of law is an excuse.
That is a legal maximum. That is what I'm relying on.
Legal. Has it been accepted by the courts of our country?
But that your lordship may kindly see the judgment, but everybody is not presumed to know the law, my lord. So far as your lordship may kindly see. That every person knows the law.
Which paragraph?
Well, my lord, I flag marked it, paragraph, second paragraph at page 6. Your lord, copies? Yes. My respectful submission before your lordship is
In what context? In a taxation matter?
in a taxation matter where the
Taxation matter, it says that there was a right which was ingrained into an SSC.
Yes, sir.
To claim an exemption.
Yes, sir.
He did not claim an exemption.
Yes, sir.
Later on, he wanted to claim an exemption. If your waiver was used,
By the
that
government.
you look, you have waived your right, now you cannot claim an exemption. This is a statutory right which was duly recognized in that sense. In this context, it was said that once the statute permits or gives a right of an exemption, then in that event, it cannot be waived. In that perspective, it says that there is a common knowledge that everybody cannot be presumed to know everything or the all proposition of law. And it also says that it is also not an excuse that I do not know law. And then and these observations came in a Faulkner's judgment came in 1847 or 46. That time the community, the society was different. We are talking in 2026 in a jet age or in a technological age where we are standing today.
Well, my respectful submission and the points of law which we
I think,
raised.
I think everything has come.
Filing the counter affidavit, the notice was issued way back in October. Counter affidavit has been filed. It's a question of debarment, blacklisting, along with invocation of bank guarantee. During pendency of your of the petition before your lordship, they have invoked the bank guarantee. They have invoked and encashed the bank guarantee. Although very fairly they say in their counter affidavit that the encashment of bank guarantee shall be subject to outcome and subject to further orders of your lordships. However, Millets, I have taken out an application with relation to the encashment of bank guarantee for restoring the same. Your lordship may kindly consider issuing notice in that IA, and also Millets, I'll take instructions on the rejoinder which has been served upon on the reply counter which has been served upon me today, Millets, at 3:30. So that's that IA. Millets is 13595 of 2026.
He's representing what if it's required, serve him a copy.
He has. He already has.
So, you want to place it?
Kindly have it. Give me some time, because exactly
how much time will
on 18th, it could be taken up on 18th, subject to my lord's.
What it is? How the rest of it?
It is submitted by Mr.
He may take instructions on that IA that I filed. IA1.
I have indicated in my counter affidavit already invoked and say subject to the result.
Very good. Great.
Item 29.
In a public auction for Sanchez, Pitson was the highest bidder. And after becoming highest bidder, there was a demand made under Rule 27(7) without specifying what is the royalty. And there was royalty. Royalty. What is the royalty? What is the royalty? Well, no, there is a catch in it. Well, there is a catch in it because environmental clearance was not given. The advertisement was for 1,80,000 cubic meter, and the environmental clearance was in advance. Environmental clearance was for 54,000 cubic meter. Also, can we Rule 27(7)? This we have quoted. Rule 27. What should be the royalty there? Pre-amended rule. I think there is one judgment which we have delivered with this on that. Regarding these additional charges and ascertainment of a royalty.
Unless this was at the stage of prior to the execution of the leave manager. In that case, it was after the execution of leaves. The judgment which your lordships had passed. And this was in 2018 minutes. So the agreement as such has not been executed with the petitioner. Because of undue dues, the lease was cancelled. The bid was cancelled.
No, there is one. This is in relation to 2714. Sorry, madam? Rule 27, sub-rule 14. No, sub-rule pre-amended to, this is related to pre-amended 27(7). The pre-amended rule. Amendment also, of course, amendment is same provision is there. Same provision is there. 1/4 of the total amount of royalty. Within 15 days of such intimation. Sub-rule 14. Sub-rule 14, the amended rule. Before amendment also, the 7 was there. It says that within 15 days of such intimation. Yes. The selected application can be filed and to deposit an amount which will be calculated in such a way. Yes. That it shall be equivalent to 1/4 of the total amount of royalty and additional charges for minor members. But and the amount of contribution payable to the district mineral foundation and environmental whatever the fund together with the reduced by the amount of honest money. But what they did, they instead of asking for 1/4, they demanded the entire amount. And that too, after that, that is the demand is illegal, and consequently the cancellation also illegal. You also kindly see page 22. 28. Page 28. Page 28. Page 28, Annex 4, serial 4, royalty. They demanded 2,86,74,000. Other demands are there, but 2,86,67, and they asked me to deposit within that is the entire amount. And what happened? Well, what happened? The inventory clearance was given only for 54,000 cubic meter. So automatically the royalty amount was reduced. And also, let's kindly see the page. And because they demanded within 7 days. 7 days, that was during funny time, so I could not take. Immediately in the 110 letter, they cancelled it over 29.
Very interestingly, they land written note, page 29, they cancelled it. And 2 days after, they offered them to the second highest bidder. And second highest bidder, they demanded only 27 lakhs. Second highest bidder. 27 lakhs, they demanded only 27 lakhs. That's the one proof. And second,
No, when
page 29.
By 2019. It was cancelled in 2019.
That's why I'm asking. When they cancelled.
They cancelled page 29, madam. Page 29. Annexure 5. They understand? Is to
Now, what are you challenging?
I am challenging this document also, and subsequently the appellate order, because I had challenged this in the writ application. This Honorable Court directed me to prepare appeal before the appellate order.
Where is the appellate order?
Appellate order is just prior to that, you also kindly look at page 221. 221. 221. What happened in the meantime, my lord? You also kindly see. Page 221, my lord. No, appellate order, page 94. Prior to that, only for minute, your lordship may lordship to look at page 221. Page 52, sorry, page 221. Sorry, page 221. Regender, regender page. Regender. Annexure 16 to the regender. Annexure 16 to the regender, which is paginated. Page 52 of the regender. I hope it is paginated.
Flat 4 minorities.
What up? Sorry, madam.
Flat 4.
Flat 4. So what happened, my lord? In the meantime, the second bid, they accepted the second bid. They asked me to deposit 20, as per 27.7, 1/4 of the year. And the lease was granted in favor. But thereafter, subsequently, lease was cancelled in favor of second bidder. So he challenged in the writ application before the Honorable Court. This Honorable Court allowed the writ application and restored the lease. And that was challenged before the Honorable Supreme Court. Honorable Supreme Court satisfied the judgment of this Honorable Court and did not proceed further, did not say what will happen. And in the meantime, when we came to know about the Supreme Court judgment, because we are not aware of this, we are aware of this section, this Honorable Court judgment, because I filed intervention petition in that case. But we didn't, when we became aware of the Supreme Court judgment, my lord, thereafter we found that appeal has been dismissed. So appeal, page 52, my lord, page 52, annexure 16. Page 52 is the This is the letter to the second highest bidder.
Letter 2.
Letter to Ranjan Kumar Potting is the second highest bidder. The deposit of his interest with security money and as per Rule 27.7 of the OMMC Rule 2016, 1/4 amount of royalty, additional charge, and the minimum guaranteed quantity shall be kept as the interest with security deposit, which amounts to 26,28,450, and along with additional performance guarantee of 5 lakh, therefore we are requested to know. So they asked, but they directed, they asked him to deposit 26 lakhs as per 1/4, as per the environmental clearance. And thereafter, but they asked me to deposit the entire amount, 2 crore 87 lakhs. That is not, rule doesn't permit that, they will not demand the entire amount. And what happened, my lord, so that is the whole discrimination here in this case. And my total case will be that the demand is totally contrary to rule, and the cancellation is automatically illegal. When cancellation is to be cancellation basing on that non-deposit.
There is no order, 94.
Appeal order is 94.
That is the court claim 2021 order.
Yes.
110.
110/2021. What happened after knowing about the, actually when second bidder got this judgment of this HON'BLE court, we had said that our fate is sealed, so we didn't proceed with the appeal because our fate is sealed, because we are not going to get it. So after knowing about the Supreme Court judgment, my lord, we applied for certified copy of the appellate court order. 22 on page 48, 22 and 26. That page 94. Page 94, 22 and 26. And thereafter, my lord, use it. So when we came to know about it, we filed it application.
But it's just one point, minus the petitioner, instead of hinging on to the past, present, embrace the present and look forward to the future, minutes, because this is back in 2019. It is back in 2018, minutes, when the auction notice was issued. Thereafter, minutes, no right persists at the moment, not in favor of highest bidder, second bidder, or third bidder. So, minutes, right now, when e-lottery is conducted in the future, then she has the liberty to participate in that e-lottery. This is in tandem with an order passed in earlier matter today, Milettes, because if something has to be done in a particular way, it has to be done in that way. Milettes, in terms of Rule 27, through e-lottery, Milettes, the process has to start and then he can participate. Now, he cannot go back to 2018 to a auction notice which was issued in 2018 and say that based on that you give me the these.
My lord, that aspect has been sealed by the HON'BLE court judgment. When the third bidder had filed it application for this HON'BLE court, this HON'BLE court had categorically said that it will be the amended rule will be applicable, not the amended rule, because that was the submission. That was the submission before the HON'BLE court. My lord, also same source. In this order, this have that page 147 look and before. Your lordship judgment. That is your lordship judgment. And the delay, my lord friend is saying about the delay part was when we had again at the cost of repetition, I have to submit that because at the time of when the second bidder spirit was allowed, so I thought that my fate is sealed. So I didn't proceed with the actually I didn't prosecute the appeal properly. Thereafter, I didn't know about the Supreme Court judgment. When I learned about the Supreme Court judgment, immediately I wanted to know what has happened in the appeal. And thereafter, 22 and 26, I applied for the separate copy of the order and also kindly see page 147. The amended. Lordship will get it. For the hearing, I will take some little bit more submission.
You want a CAV or orders on 11? For orders on 11.
You lordship allow me to make submission only for 2 minutes.
We have so patiently we heard you.
Yes, my lord. I am always for that only. Only 5 minutes, my lord.
Well, sir, interim orders may be extended.
Whatever is there.